That made you time to show you hearing on it.
Good to see you. Okay, let's see, this. Yeah, it was a matter, as the court recall, when the defendant was. So placed on probation, right?
Do you know, Judge?
No.
This was a jury trial where the jury gave him 2.5 years in prison, and then
Okay.
they asked for an appeal bond. We had a hearing. You told him that if he would go get treatment, you might reconsider it. And so he went off and did treatment.
Yeah.
He
It
successfully
was a
completed
90,
his
it was
90-day
probably
rehab.
90 days. So what we have is, this was based on a motion to set an appeal bond filed in December. And then the court ordered that we go to a facility for treatment and for at least 90 successive days, which it looks like that has happened.
Yes, Judge.
And there's no report or anything. Well, I guess
That's my problem with this whole thing is we don't have anything from the facility saying how he did. We just got he's out after 90 days.
Yeah, I can get something.
we,
My-
the day you did it, do it, and we'll come back.
Okay.
But we gotta get something that shows, I'd like to know, especially for setting other terms and conditions.
We may have it. Okay. As you know, I've been a little busy in here, so,
I don't know if you know that, but I've been busy.
you've been watching and judging. You see, you emailed it to me or to Randy? Okay. Okay, so she probably.
As amusing as this is, watching you fiddle with your phone and attempt to pull out an email or a text, there is something.
There is.
You're not just typing something in right now.
Using that AI generator, are you?
Where is the
They're
where
texting
is
and
the
saying it's in-
appeal? What's the appeal? Have y'all filed
We filed a notice of appeal. I think we,
when's the brief due?
I don't even know that we have a briefing schedule yet, Judge.
What's the problem?
Hang on, this.
Being set for misdemeanor 4/30/27.
For his MTRP on his misdemeanor.
Yeah.
Okay, I'm looking.
Did you?
Good morning, Lewis's response.
No.
Is that right?
No, this is the dismissal. This is the.
Oh, Morris.
This is what we haven't done.
Oh.
The other one was a dismissal that I'll give you in a minute.
Let you look for me. I'll look now.
Hey, Kendall, could you tell the jury we're going to need about 10 more minutes, please, and thank them for their patience. Thank you. Is this all there is? It's a succinct, just this,
Yes, Judge. I think
that
so.
one paragraph?
If you-
Okay.
If you move the,
Is there more to it?
I don't know, but if you use two fingers
On the screen.
up and down on the mouse, no, it doesn't.
On the mouse, you have to do it that way.
In the past.
You don't have a touch screen. I don't lawyer like you.
Well, no. Oh, I see. You got to move it up for it to go down.
It enter twice to exit, Judge.
I want to see how you drive a vehicle. You down Interstate 10 in reverse? Is that what you do? You're going
In
down
my
Interstate
vehicle,
10 in
you
reverse?
reverse, you push forward on the lever, you want to put it in drive and pull back. I don't know.
I need this to be converted to something in writing. So, oh, fine. Okay.
Ellie's pretty a copy.
Ellie's printing it off, Judge.
Well, I don't find. You do too.
We're just gone from the galleries.
You and Jimmy.
All right. So this is a 12-step program. What they're saying, he's gone through 9 steps. What about, and I'm not really familiar with what steps 10, 11, and 12 are.
Yes, Judge.
Since I've never really seen what those are. I don't know what that is. What are they? And it's obviously not part of the inpatient. So is that right?
I would
Is
suspect
it an outpatient or something?
outpatient aftercare that he's doing.
Can I find out what that is? Can anybody, real quick?
If you hand me the computer, I'll find it real quick for you.
Okay, it says, and completed his 8th and 9th step amends process. As a sponsor and continues to utilize sponsor upon discharge, successfully completed treatment episode on April 8th. So 4th and 5th step. And 12 steps that cover the program. I just need to know what's
next.
well, what steps are still required.
So it's,
Yeah.
sorry,
Yes, ma'am. Go ahead. Do you know?
it's a 12-step process. So like
I knew
AA,
that.
well, it's
What
like,
are they?
they're the,
What's still left?
so he'll go to AA meetings and that's part of their step process. So he made amends and then the last few steps, he'll continue working with a sponsor to complete, last 12 steps of recovery.
Right. And Judge, the last step is kind of a continual step, which is that you essentially will eventually become a sponsor and sponsor other people and serve the process of sponsoring other people. And that may have been what you just said. Essentially. Yeah.
All right.
Probably sounded better.
Okay. All right. What else are you asking on this?
Judge, we're just asking that you, as a practical matter, you set an appeal bond. He posted the appeal bond and went and did the 90 days that you asked him to do. So now we're asking the court to maintain that appeal bond, I guess is the best way to say it. Chris Romano has the bond. He will do interlock or scram or whatever you want to do on that front.
Of course, we objected whenever this happened. We still object because he was on probation out of misdemeanor court when he committed this offense for DWI third. And so
Here's what we're going to do is
yeah,
I'm going, I agree with the concerns of the state. I'm going to release you on this bond. You must complete timely the full 12 steps in the recovery program that in this intensive residential treatment plan that you attended that still are required of number one. Did I set a bond of amount?
You did, Judge.
Okay.
He posted, I don't know how it works because he had to turn himself back in. So I don't know.
Revoked the bond yesterday.
Oh, okay.
And
So,
released it
okay.
in order for him to get back into custody.
Okay. I got it.
That's
I
fine.
got it. So he'll have to repost that bond, I guess.
The bond shall be reposted. You shall not operate a motor vehicle at all. Number one. Find that you drive a car, an automobile, or any mobile device that's on the street, whether you're intoxicated or not, it will be a violation of your bond. Number two is there's no alcohol. And the scram device, I guess, is what we'll use for that.
That's fine, Judge.
And trying to think of some, some other terms, because I want to ensure that, I know if you've got a scram device, but do we have something that can show if there's alcohol in the system?
That would.
That's what the scram
The
score
scram
is.
will
Yes,
do.
sir.
What other conditions?
Judge, that's the main problem is, he hasn't had any other criminal history that I'm aware of.
No.
It's just been the
No,
alcohol
but this is-
intoxicated, so.
but this is serious.
Yes, sir.
You got that car stuck on the stop on the freeway. It's a 4,000-pound missile. And you didn't even know what planet you were on. But this has happened before. You didn't fix it. Here you are. And you're supposed to be a role model in the community as a business leader, sir. This is not setting a good example. Fix that, please.
Yes, sir.
Okay. For the safety of yourself and all others.
Yes, sir.
Are there any other conditions from pre-trial services that we need to?
Possibly home confinement, if you want him to stay at home and not go anywhere whatsoever.
Judge, our,
That way there's no issues about him traveling.
Well, a GPS device will show where he is.
Yes, sir.
And you could, I want you only to go from home to work in the most direct route possible. You can go from home to a hospital if you need medical care. You can go home to a place for food if you need food, and home to church, religious.
Worship.
Mass or worship in the most, and all of this is the most direct route possible, and to and from the attorney's office.
and then also AA meetings, Judge, or outpatient.
Well, if
care.
it's required,
Yes.
yeah, he's got to get to that, and he can't fly. So you would have, if you're at Alcohol Anonymous or other programs that are part of this recovery process, you are allowed to go there to and from in the most direct route possible. But again, if you, unless you walk to, you can't drive a vehicle. Somebody is going to have to operate a vehicle. I want to review it in 4 weeks, every 4 weeks, to see how things are on this, because it's intensive, but it deserves attention. Constant attention by the court. Are you able to follow all these, sir?
Yes.
Okay. Anything else on this? State and probation?
Yes, sir.
Thank you very much, Reverend Sensor. All right. Christopher Smith? Add on. Okay.
Thank you.
That's all right.
We did. It's just my home. They use 8,000.
Normal rip.
Yeah.
Can't appeal a motion.
All right, we have one more matter. It is in the matter of Christopher. Is it Joseph?
Yes,
It's yeah, this writ is misspelled. And Houston Smith. And that's you.
yes, yes, sir.
And Mr. Gerges here is your attorney, and the state's attorney is present. There is a motion or an application for writ of habeas corpus requesting a reasonable bond with the inference that the 800,000 was not reasonable. At least one man's opinion says that. Let me look at this circumstances. You know what I need to
There.
public safety report?
Look, there.
I've got a public safety report in.
Thank you, Ellen.
You're welcome.
Good move, quickly.
And the people too, just put it on the website, please.
This is all he's been ever arrested for?
Yes, Judge.
That's true.
Yes.
Just you can speak up. Okay. Sometimes helping on the. All right, generally, bonds are set based upon criminal history and circumstances of the offense. And then other circumstances become an issue. That is, if a bond is going to be posted, the ability to follow up with the requirements of a bond. Where do you live? I know where you're residing now, but do you live in Groves?
No, sir. I live in Needleland.
You previously lived in Groves.
Yes, sir.
I grew up in Groves. This is not what Groves stands for. All right. I think I see here why. Imagine who set this bond originally.
And Judge Sharu and Judge.
I see why he would have set this. According to the probable cause affidavit here, law enforcement obtained warrants to get certain accounts that you were associated with to something called KIK Messenger, which I'm not real familiar with. But what they recovered, the police recovered, was a large amount of what they claim is child pornography that was associated with you here. The probable cause affidavit states that the writer, which is Detective Perkins of Needleland PD, observed 40 images and videos depicting child pornography, 31 of the videos depicting children being sexually assaulted. Further, according to this statement, the writer, Detective Perkins, the author of this probable cause affidavit, observed the suspect, you, to have uploaded photographs and videos of yourself to the account. And he was able to verify you by comparing the videos to your driver's license. Also, and most probably the most disturbing part of this, I also, according to the detective, it was observed that you have communicated with other individuals on KIK, this system, information system, about your sexual fantasies, which included sexually assaulting and murdering infant children. Can you explain that?
Judge, I'm going to ask him not to answer that question.
Oh, well, anything else?
No, other than I don't even know if the bond is sufficient as it
Yeah.
is, but
One of the most disturbing things I've read in my career. And I've seen it all, I thought. And number one, child pornography continues to be abusive to the child. It continues to victimize children when it's out there. Child pornography is bad enough in its very essence. But when someone professes to, let's see, professes sexual fantasy of sexually assaulting and murdering infant children, that puts it into the potential harm and jeopardy of others in a new light. I don't think, and I've been a part of, from the Jamesburg murders to all types of crimes. But I don't think I've ever read such a horrifying and concerning statement about someone's thoughts, a human being's thought that murdering children would be amusing. Well, that's the inference. $800,000 is, I'm not, I'm not lowering it. Judge DeRuin, I find, based upon the circumstances of this case, a fair determination. But if you happen to be able to post this bond, we have to have a hearing so that conditions of release would be appropriate based upon these circumstances, which would be a long list plus a list that would include all thoughts I would have to ensure that the safety of children could be preserved if you were released. And it would include at least home confinement, no access to internet. Are you married or single?
Like I'm married.
Sir?
He's married, Judge. Yes.
Any children? Do you have any children? Okay.
No, sir.
Do you cohabitate with your spouse? Are you living with your spouse? He's down.
Well, he went down on his first shot.
Oh, go ahead, yeah, man.
Yeah.
On his face.
Emergency medical services.
Thank you. Please,
He
please. No.
he passed out.
Just relax, relax.
Check the radio.
Thank you. That's good. Don't get up, just sit. Just sit on the floor. Sorry, I apologize. Sit right there.
Where's he bleeding from?
His nose.
It keeps head
Hit
up.
his face first, Judge. Luckily he didn't do that, but he hit his face first, so.
Need some medical services. Thank you. Yeah, he's bleeding from face wound. All right.
The jury.
All right, we are in recess on this matter right now. Thank you.
And just like that, the courtroom atmosphere changes completely. No matter how serious the allegations are, the court has a legal and ethical responsibility to ensure the defendant receives immediate medical attention. Notice how the proceedings stop instantly. That's exactly how the justice system is supposed to work. Cases can wait. A potential medical emergency cannot. It's a reminder that due process includes protecting everyone's safety inside the courtroom, regardless of the charges they face.